Hey Law Nerds, I'm finally back. This is Professor Tracy with a follow-up to my video on pre-existing legal duty. This time we're going to see how that rule meshes with contract modifications. So what we have in mind here is that the parties already have a contract in place and they're seeking to change one or both of the duties that are owed to each other. So let's jump right into the material. First, we'll start with our general rule regarding modifications. So remember that the three elements of a contract are offer, acceptance, and consideration. Our focus having been on that last element so far, consideration. When there is a contract modification, there is a need still for all three of those elements. Our focus in this video, as with the last several, is on the element of consideration and how that fits with modifications. So let it be said that the biggest obstacle to a modification is the pre-existing duty rule. Because if you think about it, with a existing contract, the parties already owe legal duties to one another. So if we need consideration, then we have to decide, well, how does that come about? Because it cannot be that they're just promising to do the same things, or that just one of them is promising to do the same things, because the pre-existing duty rule will be an obstacle. But let's see that in practice. We're going to start with an example here in the negative, which I don't normally like to do, but I do think it drives home what I'm trying to say here about the pre-existing duty rule being an obstacle. So we've got Bob and Bo back at it. You again? What on earth did Tracy do to Barb? Hey, that's not nice. You're right. I'm sorry. Actually, I'm glad you're here. Really? Yeah, of course, Bo. See, my whole family's getting together at my summer home in Lake Placid, New York, 2 weeks from now. I desperately need someone to go up next week to clean the place and get it ready. What do you say, Bo? Are you up for doing it? Please. I'll happily pay for you to fly up and back. I'll also pay you $1,000 for the week of work. So Bob here has promised to pay Bo his travel costs up to Lake Placid and $1,000 for his week of work getting his place ready up in Lake Placid. And now Bob says, Bo, what do you think? Okay, I'll do it. So Bo has promised back he's going to clean Bob's summer home. So we know that is a contract, right? There's a promise in exchange for another promise. There is consideration. Bob's promise has induced a promise back from Bo, and they're both legally binding commitments. So we know that this contract, the original contract, and I say original as compared to the modified contract that will be coming, is fine, right? It's got consideration. It appears to be legally enforceable on both sides, meaning Bo's promise is enforceable, as is Bob's. So a week passes and Bo is now at Bob's summer home in Lake Placid. Bob, your summer house is a freaking mess. I'm not finishing your dumb cleaning job unless you pay me double. So one of the things I'm noting here, and this is something we'll talk about even more as we get a little further in the video, is this idea of duress. Remember that Bo is already up in Lake Placid. Bob has already paid for him to go there. And so in a sense, Bo's got Bob over the barrel, right? Like that Bob doesn't have much of a choice. So there is this question of, is Bo really acting in good faith, or is he making a threat to breach the existing contract he has with Bob in order to get more money from Bob? If so, that's duress, and it's not acting in good faith. It's a breach of what's called the implied obligation of good faith and fair dealing. So that's something we need to be aware of. But separate and apart from the question of good faith, bad faith, duress or not, there's a question we'll see about the pre-existing legal duty rule and the existence of new consideration in this particular example. Fine, I'll pay you double, Bo. I just need the work done. So Bob has agreed to pay Bo $1,000 extra to do the job. So he's modified his promise, right? Remember, initially, under the original contract, Bob had said, I'll pay your travel expenses and I'll pay you $1,000 for the work. Now he's doubling it, at least the amount paid for the work. So it's $1,000 more. So he's paying $2,000. So the question we have to ask is, well, is Bo promising anything more? And the answer is he's not, right? He's promising the same cleaning job. So we have to ask ourselves, well, does that work as a modification? The modification being that Bob is going to be paying extra, $1,000 extra. So let's look at how this breaks down. Remember the original contract? Bo had promised to clean Bob's summer home, and Bob promised to pay the travel and $1,000. Under this modified agreement, we know that we just said Bob is paying Bo an extra $1,000, and the only thing Bo is doing is the same cleaning job. And so we said that we need all the elements of a contract, including the element we've been focused on, which is consideration. So if we're asking, is Bob's promise supported by consideration, his promise to pay an extra $1,000, which is the alleged modification here, the answer is no, right? Because it did not induce any new detriment from Bob. Because of the pre-existing legal duty rule, Bo already had an obligation to clean Bob's summer home under the original contract. So when Bob goes to promise to pay extra, it's not inducing any new detriment. So there's no consideration coming back for what Bob has promised. He's just trying to get Bo to do the work he already promised to do. So when we ask, does that work? No, right? It's not consideration for Bob's promise. So it's a failed modification. And I told you out of the gate that this was going to be an example of a failed modification, but I think it illustrates well, to start in the negative here, about why the pre-existing legal duty rule is an obstacle that needs to be overcome when we're thinking about a contract modification. So let's look at the flip side of this and see a successful modification. So again, we've got Bob and Bo, and we're looking at basically the same example with a few different facts. Bo, my whole family's getting together at my summer home in Lake Placid, New York, 2 weeks from now. I desperately need someone to go up next week to go do a quick clean of the place and get it ready. The house just needs some light dusting and vacuuming. What do you say, Bo? Are you up for it? Please? I'll happily pay for you to fly up there and back. I'll also pay you $1,000 for the week of work. So again, we have a promise from Bob saying, I'll pay travel, I'll pay you $1,000. One of the differences here is Bob's defined the scope of the job, right? He said it's just some light cleaning and vacuuming, right? Some light dusting and vacuuming. And so again, we had to see, well, how does Bo respond, right? The suspense is killing you, I'm sure. Here, Bob says, Bo, what do you think? Okay, I'll do it. So Bo has promised, again, to clean the summer home. But we know now the specific scope of that job, which is just some light dusting and vacuuming. So again, this original contract has consideration that Bob's promise has induced a detriment back from Bo. And if we looked at it from the other side with Bo's promise, we could say the same thing, that his promise to Bob has induced a detriment back. So a week passes. Bo's now at Bob's summer home in Lake Placid. He calls again. Bob, your summer house is a freaking mess. A light dusting and vacuuming might took us. The place is filled with garbage and mold. It needs a complete scrub down. The job's way more extensive than what we agreed to. I'll do the dusting and vacuuming as agreed, but the place will still look bad. If you want the mold and the garbage dealt with, you'll need to pay me double. I get it, Bo. I'll pay you double. I just need the work done. So again, Bob is promising to pay an extra $1,000. It's just like in the previous example. So his promise is the same, but the issue in the previous example was it didn't induce any new detriment from Bo. In this case, Bo's promising back a larger cleaning job, right? He's saying, not just I'll do the same cleaning job, which was light dusting and vacuuming, but I'll deal with all the garbage and the mold. So it's a larger cleaning job. So let's compare it again to see, is this one successful or not? So again, remember, original contract, a promise from Bob to pay the travel and the $1,000. Bo's saying, I'll clean the summer home, but we know what was intended there was the light dusting and vacuuming. When they go to modify it, Bob is saying, I'll pay you an extra $1,000 on top of the travel in the original $1,000, and it's inducing a new detriment. So Bob is not just promising the same thing, right? He's promising to do a larger cleaning job that now includes a deep down dealing with the mold and all the garbage that's in the house. So it's not just the same thing, it's additional or different consideration to what he initially promised. So the pre-existing legal duty rule is not an obstacle here, because in fact, Bob's promise is inducing a new detriment, new consideration back to him. So we know there is consideration. This is going to be a successful modification, unlike the first example where Bo was just promising the same thing and the pre-existing legal duty rule was a problem. So let's look at the basic categories of successful modifications. And basically, most modifications will fall into one of these. There might be some that fall somewhere else, but it's unlikely, especially since one is really broad, right? This category of there's additional or different consideration, just like in the previous example, right? We go back to this example and remember the original contract, as we just said, was Bob promising the travel, the $1,000, and Bo promising to clean the summer home, which was defined as the vacuuming and the light dusting. And that there was a successful modification because Bob's promise to pay an extra $1,000 was inducing new consideration or additional or different consideration back, in that it was a larger cleaning job that included dealing with all the mold and the garbage. So let's look at another example, which is similar, that there's additional or different consideration. And this one's slightly different, but it'll give you a good example of what do we mean by additional or different consideration. Because here, it's not really just the scope of the job that's changing, but some of the dates, right? So let's see this. This is important to understand that Bob here, ready to go as a gardener, farmer type, is saying to Barb, I will weed and plant your garden by September 1. And Barb is promising back that she will pay Bob $600 to do this by the end of September, by September 30th, 9/30. So now we know it says Bob weeds and plants the garden by September 1. He's fulfilled his part of the contract, but Barb is yet to pay. And remember, she has to pay by the 30th. On September 6th, after Bob has completed his part of the job and he's owed the money, Bob and Barb attempt a modification. In this context, it's important to say what are the rights and the duties that are still left. Bob's fulfilled his duty, so he has a right to receive $600 by 9/30, and Barb has a duty to pay $600 by 9/30. Pretty straightforward, right? That Bob has a right, Barb has a duty, because her right to have her garden weeded and planted has already been done, right? Bob's done that, and Bob's completed his duty. So here, how do we get a modification? Well, if Barb says, hey, I will pay you early, instead of paying you on the 30th, I will pay you 15 days earlier on the 15th, and Bob is saying, and I waive my right to the full amount. I'll accept $500. So in sense, you could say Barb is saying, I waive my right to wait until the 30th to pay you. I'll pay you early. And Bob's saying, in return, I promise to waive my right to the full payment, to the full amount, to get $500 now. So he'd rather have the money early than later, and that is Barb giving up her right to wait until the 30th. So there's consideration. They're both waiving rights that they have. That Barb's right, waiving her right to wait till the 30th, is inducing Bob to waive his right to the full amount. So that would be additional or different consideration. It would be a successful modification. So what about the settlement of a disputed debt? This is going to be similar. If we look at another example here, in the same sort of context here, right? Same setup, that Bob has promised to weed and plant Barb's garden by September 1. And in return, Barb said, I'll pay you $600 by the 30th. Same original contract as the previous example, but now we're told Bob weeds and plants the garden by September 1, okay? But this time, when Barb looks at the job that Bob did, right? When he says, I'm done, she honestly believes that Bob did a poor job and refuses to pay him the full $600. So she's saying, I honestly think you didn't do the job you promised to do, and therefore I could sue you and I'm not going to pay you. So there's a dispute, right? A dispute over this. How much is it that Barb owes? Right? How much is it that Barb owes? Did Bob fulfill his duty under the contract or not? So we could again say, well, what's going on here is allegedly, he claims he has a right to the full $600. He's completed his duty under the contract. Barb is saying, no, I have a right to sue because I honestly believe he did a crappy job. And so how would this work? Here, Barb would be saying, I'm going to waive my right to sue you because you did a poor job. And Bob is saying, in exchange, I waive my right to the full amount. So the disputed debt here is Barb's debt to Bob to pay the $600. It's disputed because she's saying you haven't earned it yet. You haven't earned it. So in settling that, Bob's going to agree to take less in order to avoid Barb suing on that debt, right? Or vice versa, right? In order for Barb suing, not on that debt, but on his poor performance. So we would have a successful modification. There's consideration on both sides. So an accord in satisfaction is similar to the settlement of a disputed debt, but it's a little bit wonky. And frankly, it's not necessarily the thing that exists in every jurisdiction now, but let's take a look at it. Let's assume we've got a very similar setup where Barb is going to pay $600 for Bob to weed and plant her garden. Same setup we've been looking at. And again, let's say that same situation, Bob weeds and plants. Barb honestly believes it's not a great job. She could sue on it. But here's what happens. We have what's called an accord, which is, instead of it being a modification of the original agreement, this is a separate contract rather than what we saw with the settlement of a disputed debt, which was just a modification of the original agreement between Bob and Barb. In this case, it's a separate agreement in which Barb is saying, I will not sue on our original contract, and you will agree to accept only $500. So it's a similar result, but procedurally what's going on is they have a separate agreement, an accord, which is like a settlement agreement that they've agreed to. And this separate agreement will suspend the original contract, right? Any obligations under the original agreement are suspended by the accord. And then the satisfaction of it is the payment and the acceptance of the $500. It would be Barb paying the $500 and Bob accepting that, and therefore, and Barb in exchange waiving the right to sue. So the satisfaction, the performance of the accord is the satisfaction we're talking about, and the result of that is that not only is the accord that was agreed to, this separate agreement, discharged or completed, but the original agreement is that was suspended. So both agreements would be discharged, and that would be the end of it. If the accord wasn't performed, wasn't satisfied, then there would be a question about suing either on the accord or suing under the original agreement, and there's a choice that could be made there under which one to pursue. So let's look at mutual rescission. This one's pretty straightforward. It's when the parties agree that they're just going to call things off. So here, if we go back to sort of the original contract we had in this situation where Bob is saying, I will weed and plant your garden, Barb, by September 1, and Barb saying, I will pay you $600 by the end of September. If they just agree to call the whole thing off, let's terminate our agreement, neither party has performed, which is key. To have mutual rescission, it must be executive on both sides, not executive, executory on both sides of the agreement, which is what we have in this case. Neither have performed, and they're deciding to call it off. And so remember here, that would mean Bob has a right to receive $600 by September 30th, and Barb would still have a right to have her garden weeded and planted September 1. Because remember, neither performed, their promises are executory on both sides. And what does a mutual rescission look like? It means that both parties are waiving the rights that they have. Bob is waiving his rights to the $600 by the end of September, and Barb's waiving the right to have her garden weeded and planted by September 1. So that is both of them waiving the rights and rescinding then the agreement, terminating it, putting them back to where they were before they entered into this contract that they now regret for some reason or just decided to call off. So that's a mutual rescission. There's consideration on both sides. It would be a successful modification. Let's look at a novation, which again is a very particular kind of thing, just like number 3, the accord and satisfaction. So let's look at example 7 here. If we again look at this example of Barb saying, I'll pay you $600, Bob, for you to weed and plant my garden. And they both decide that, well, let's waive our rights and substitute somebody else here. So what a novation is, it's a rescission of the original agreement, just like in the previous example, the mutual rescission, where they're both waiving their rights, and the substitution of another party into this role, into one of the parties' roles. Here's Bob, right? Bo shows up, and he's now in the place of Bob, and there's a new contract. So the novation is a mutual rescission coupled with the formation of a new contract with the substitution of a new party into the agreement. So instead of Bob, it's Bo who's agreeing to weed and plant Barb's garden, and Barb is agreeing to pay him, Bo, not Bob, the $600. So that sequence of an original agreement, a rescission, and a new contract with a new party is what is deemed a novation. And so because we have a rescission in which there was consideration on both sides, and now a new party in with the promise being made to the new party and Bo making a promise in exchange to weed and plant the garden. In each of those cases, with the rescission and with the new contract, there's consideration. And so that is what's called a novation. Where we end up is a contract like the original agreement, but with a new party substituted on one side, in this case, Bo for Bob. So let's look at what I'm calling exceptions to this general rule, right? We said our general rule is that a modification must have all the elements of an original contract, including what our focus is consideration. And we said the big obstacle is the pre-existing legal duty rule. But there are some exceptions where the pre-existing legal duty rule is not, in fact, an obstacle. Well, what are those? The first is where the parties make a modification which is considered fair in light of changed circumstances, or equitable in light of changed circumstances. This is a situation where the court is saying, in equity, in fairness, we believe that this modification should be enforceable even though there is in fact not consideration. So in that sense, it's considered an exception because the pre-existing legal duty rule is not an obstacle. So let's look at an example of how this exception works. So we've got Bob and Bo now.
Professor Bob, I heard you run a landscaping company during the summer when you're not teaching.
Sure. Why do you ask?
I was hoping your company could take care of my lawn while I'm away this summer.
Sure, happy to do it. I charge $50 a week. Oh, and just to be clear, I manage the company. It won't be me doing that mowing. It'll be one of my employees. So Bob is promising on behalf of his company that he will mow Bo's lawn on a weekly basis. And Bo says in response,
that all works for me. Sign me up.
So Bo, in exchange, is saying, I'll pay you the $50 a week that you said you would do it for. So we've got here on both sides consideration that Bob's promised to mow the lawn weekly this summer for Bo, in exchange induced a promise back from Bo to pay $50 a week. So, and if you looked at it from either side, there would be consideration. So that is the original contract that's in place and it works fine. So now let the story continue. Everything goes along swimmingly until July when half of Bob's workers unexpectedly go on strike. One of the key things here is this change in circumstances when we're talking about equity and this exception. It's got to be a surprise. It's got to be unexpected. Here, this strike of Bob's employees at his landscaping company is unexpected. We're told it is. Bo, I've got bad news. I've lost half my employees to a labor strike.
Okay, what does that mean for my lawn service?
Well, the strike's not something I budgeted for. I certainly didn't see it coming. I had to hire some temporary workers to carry me through the end of the summer. I hate to ask, but the only way I can make this work is if you agree to pay me $15 more a week.
I understand. Not your fault. I'm happy to pay the extra $15 a week.
So Bo is promising an extra $15 a week to Bob, and in exchange, what is Bob doing? He's saying, I will do the same lawn service we agreed to under the initial contract. Well, in the very first example, we said that was a failed modification, right? So let's take a look. The original agreement, remember, was Bo saying, I'll pay you $50 a week. Bob saying, I'll mow your lawn weekly. Then in this supposed modification, Bo's saying, I'll pay you an extra $15 a week. And it's the same lawn service that Bob is promising. So Bob's promise to pay the $15 a week, this alleged modification, isn't inducing any new detriment. And the pre-existing legal duty rule, if it applies to this, would be an obstacle. It would prevent this from being a successful modification because there would be no new consideration being induced by Bo's promise to pay the extra money. So we would say, no, there isn't any consideration. So it would be a failed modification, as we said way back in example 1. But we said this is an exception because it is a change of circumstances, an unexpected change in circumstances that has, in fairness, resulted in this modification. So the court will say, in fairness, this is something that, although there's not any new consideration, it was induced by a unexpected change in circumstances. So in fairness, in equity, we will allow this modification to stand. So it's an exception to the rule that we always need new consideration, or to the idea that the pre-existing legal duty rule will be an obstacle. So that's why it's in our list, right? So that was fair in light of changed circumstances. Our second exception is a contract for the sale of goods under the UCC, or what's called the Uniform Commercial Code, which we've run across in previous videos. So this is example 9, where we're under the UCC. Barb, we haven't been able to catch up in forever. Yeah, enough. Let's get down to business. Okay, well, now I remember why I've missed you so much. Bob, get over it. I will pay you $200 for 10 crates of oranges to be delivered to my store by 5 p.m. on Thursday. I reckon that's a fair deal. I will get the 10 crates of oranges to you by Thursday. So Bob is saying, I'll get you 10 crates of oranges, and in exchange, remember, Barb has said, I'll pay you the $200. So in this case, we know that there's consideration on both sides, right? That Barb's promise of $200 induced a promise from Bob to pay to deliver these 10 crates of oranges. And if we looked at it the other way, same would be true. So it's this, there's consideration on both sides. The original contract, from our standpoint, looking at consideration, is A-OK, legally enforceable. The next day, Bob calls. Barb, I'm running into trouble with my orange crop. I need an extra $50 to make this orange sale happen. No problem. I'm happy to pay the extra $50. You have the best oranges in town. So Barb is saying, I promise to pay an extra $50 to you, Bob, in exchange for what? 10 crates of oranges, which is what Bob had already promised to do. So we have to look and say, is this modification? Does it work? Is there a modified contract? Let's remember, the original contract was Barb promising Bob, I'll pay you $200, and Bob in exchange promising to pay or deliver 10 crates of oranges. And the alleged modified contract was Barb saying, I'll pay you an extra $50 for the same 10 crates of oranges. We know under the general rule we looked at that a promise to do the same thing is not consideration because of the pre-existing legal duty rule. It's not a new detriment, that Bob is not incurring any new obligation that he didn't already have. He was already bound by the original agreement to deliver the 10 crates of oranges. So we would say that's not new consideration. It's not going to satisfy the element of consideration. So does that mean it's failed? Well, we know the answer has to be no, because we're looking at exceptions that it's successful. Well, why? Remember, we said if it's under the UCC, and remember to what the UCC applies. Article 2 of the Uniform Commercial Code, the UCC, applies to any contract for the sale of goods. Goods are tangible, movable property, which means in this case, oranges, right? So personal property, movable property could be a car, it could be a pen, it could be bagels, it could be your watch, your phone, your textbook, any number of things. It could be an RV. Size doesn't matter if it's movable property. So that we're under the UCC, and the UCC says there doesn't need to be additional or different consideration so long as the modification is occurring in good faith. And remember, we raised the question way back in example 1 of, was Bo operating in bad faith? Was he threatening to not follow through with the original contract just in order to extort extra money from Bob? Well, that would be bad faith. In this example, there doesn't appear to be any bad faith. That Bob seems to have hit a genuine problem. He's asking for money, and Barb is willing to pay that extra money to help Bob out in the bind he's in. It doesn't matter, because we're under the UCC, we don't need that additional consideration. It's an exception. Let's look at an example where it's not going to work. So another example where we're under the UCC, we're still looking at goods, a contract for the sale of goods, oranges, and we're picking up with this hypothetical at the point in time where they've already had their original agreement to the purchase and sale of oranges, and Bob's calling to say there's a problem. Barb, bad news. I've run into a bit of a money problem. I already spent the $200 you paid me, so I don't have any money to deliver the oranges to you. Bottom line, I need an additional $100 if you want your oranges. So we have this question, right? Is this just duress? Did he misspend the money and he's like, well, if you don't pay me, I'm not going to follow through on the contract we already have. And remember, if we have a legit contract already, the parties are already legally bound to perform. So a threat not to follow through is a threat to breach the agreement, to do something that Bob has no right to do. And so here he would be acting in bad faith. In this case, as opposed to the previous example where something legitimately happened that wasn't his fault, he had a legit reason why he needed additional money. Here it appears he just misspent the money. So here Barb replies, really? I need those oranges. I guess I have no choice. I'll pay the additional $100, but I don't like it. So Barb is promising to pay the extra $100, and Bob is promising, again, just the same 10 crates of oranges. So it's very similar to the last hypothetical where we said because we're under the UCC, we're okay because we don't need additional consideration. Well, let's follow this one through. So we still have original contract, Barb saying, I'll pay you $200, Bob. In exchange, Bob's going to deliver 10 crates of oranges. Now, the modified agreement is Barb saying, I'll pay you an extra $100. And again, Bob is just saying, I'll pay you, I'll deliver to you the same 10 crates of oranges. Now, we said that that doesn't work because Barb's promise to pay the extra money isn't inducing any new detriment from Bob. So but we said the pre-existing legal duty rule isn't a problem under the Uniform Commercial Code where we are. But what did we say, right? So is this a failed modification? Well, it is, but not because of the pre-existing legal duty rule. Remember, we said in the previous example, it was done in good faith. So under the UCC, while we do not need new consideration, we do need the modification to be done in good faith. And here, it would not be. It's a failed modification, right? It's not going to work. So while the promise back to do the same thing might be a-okay, it's going to fail because of the lack of good faith on Bob's part. There's not a legit reason he needs extra money. He just misspent money that Barb paid, intending for him to use it to deliver to her these oranges. So he's acted in bad faith, and now he's just demanding more money to try to make up for his acting in bad faith. So let's kind of spell this out with this UCC exception, where we said that the rules then differ depending on, are we under the common law, which, remember, governs contracts for real estate or for services, or are we under the UCC, which governs contracts that are for the sale of goods, like oranges in the previous two examples. We said if we're under the common law, we need new consideration. The pre-existing legal duty rule is an obstacle subject to our one exception, which was if it is the result of a fair or equitable modification in light of a unexpected change in circumstances. But under the common law, we need new consideration and good faith, even though we didn't spell that out a whole lot when we were looking at these contracts for cleaning houses, which were services, or mowing lawns or planting, which are all services. Nonetheless, we need not only new consideration typically, with the one exception in mind, but good faith. Good faith. That if you've read the case, the Alaska Packers case, which is pretty much in every contracts textbook, you'll see that question arise there. Although the court brings it up, the bigger issue that the court is analyzing there is the lack of new consideration, right? It looks at it and says, well, these fishermen are just promising to do the same fishing job they already agreed to. But there's also an element of bad faith there, right? Where they're already up there. The company that sent them up to Alaska to fish really has no other way to get anybody else up there. And they're saying, we're going to breach unless you agree to pay us more. So here, remember, under the UCC, we're there if it's a contract for the sale of goods. We said oranges are goods, but so is an RV, so is an airplane, so is your laptop, any number of things. So if we're under the UCC, we don't need new consideration. We just need good faith. So we have two exceptions then to our general rule that the pre-existing legal duty rule is a problem, that we need consideration. But we said two rules. One is a unexpected change in circumstances, which results in a fair and equitable modification, and an exception being that we don't need new consideration if we're dealing with a contract for the sale of goods under the Uniform Commercial Code. So one last thing I want to hit before the video's over is this question of what if we have a contract that is what we deemed a mixed contract, meaning that it is about something that involves services and goods or real estate and goods. Well, if it's a mix of goods and services, then we have two possible tests we could look at. The majority test is what's called the predominant purpose test. And under this majority test, we're told that we're going to look at the language of the contract, the nature of the supplier's business, the one supplying the services and the goods, and whether the goods or the services cost more. So let me give you a quick example. Let's suppose you go to Home Depot and you buy a refrigerator. Often, if you will pay them an additional $50 or some relatively small amount, they will agree to come and to install and set up your new fridge and to take away your old fridge. But if you are looking at the contract as a whole, what is primarily going on there is this is a contract for the purchase and sale of a good, right? That if we look at most of the cost is going to be for the fridge, right? Which at these days, you're looking at $1,000 or something like that, depending on the quality of the fridge. And to be fair, most of what Home Depot is doing is selling goods. Certainly they do, they offer various services, but they're primarily about selling goods. And if you look at the contract, it's going to be primarily about the sale of a new fridge to you. So the predominant purpose of that contract is about goods. And so we would say, yes, there is this services element dealing with setting up the new fridge and taking the old one away, but it's predominantly about goods, so we would apply the UCC. The other test that some jurisdictions use is the minority test, which is called the gravamen test. The gravamen test, and under this test, what we're looking at is when there is a problem and there's a complaint that arises about the transaction between the parties, we look and say, what exactly is the complaint about? Is it about the services portion of it, or is it about the goods portion of it? What's the gravamen, the essence of the complaint? What is it about? So if we stick with the fridge example, if it's about something wrong with the fridge, right, that there's a defective component in it, it doesn't cool the way it should, something like that, then that would be, the gravamen of that would be a defect with the goods, so we would be under the UCC. However, if it's about it being installed improperly, or the complaint is about when they took away my old fridge, they dinged up my house, that's a complaint about the services, how they were performed. So the gravamen would be, it's about the services, and therefore we would be under the common law. That would govern. So when we're looking then, if we back up just a second, when we're looking at a mix of goods and services and we're deciding, are we under the UCC? Are we under the common law? We would be applying either the predominant purpose test in most jurisdictions or the gravamen test in a minority handful of jurisdictions. But if we're looking not at a mix of goods and services, but goods and real estate, in this case, the UCC itself actually has provisions that help us out. And the way to think about this is, it says if they're minerals, if they're oil, they're gas, or a structure on the property, on the real estate, that this is how it works. That if the minerals, the oil, the gas, or the structure are severed, meaning removed by the seller, then it's a sale of goods, which kind of makes sense, right? If I already have severed or taken the minerals out of the ground or the oil or the gas, then what I'm selling you is already not, it's no longer attached to the real estate. So I'm selling you what is a good. It's governed by the UCC. And that's true with like a structure like a shed or, you know, an ice house or something that's on the property. But if the buyer's doing, and again, this makes sense, if the buyer's the one that's going to be doing the severing, the removing, then that makes sense, right? They've bought the property. They themselves are going to come in and remove the minerals, the oil, or the gas. So it's a real estate transaction that's governed by the common law. There is these other things, though, crops or timber, which this is what we've got to understand. Regardless, if it's crops or timber, regardless of who severs it, if it's the seller or the buyer, we treat it as a sale of goods, and it's governed by the UCC. So those are the rules. If we're looking at a mix of goods and real estate, it depends. What is this mix? Is it about minerals, oil, gas, or structure? Then if the seller severs, it's going to be under a good, we're under the UCC. If the buyer severs, it's real estate, we're under the common law. If it's crops or timber, it doesn't matter who's severing it. It's always the sale of goods, we're under the UCC. So I know that's a lot and this is a longer video, but I really hope that's helpful. And I will see you next time. As always, if you found this video helpful, please like and subscribe, get the word out to others. And I appreciate it very much that you've taken the time to watch the video. And I will do my best to be much quicker about getting up a new video. Thanks again. Talk to you later.